Is present.
All right, let me go to Odyssey and log in. All right, so Mr. Medellin, come on down. So counsel, is this going to be a jury trial?
Judge, we have a preliminary issue.
Yes.
So I had talked to Mr. Medellin. Apparently, his wife is in discussions with, I guess, Ernie Acevedo about hiring him.
Mhm.
I said, you have every right to do that. I'll file a motion to withdraw. He's not happy with my services. He believes I am an arm of the DA's office, helping to prosecute.
But they have their own arms. So here's the thing, you're here today for a plea deadline date. So today is your plea deadline date. Either you're accepting or coming to an agreement with the state or not. Let me explain to you things about attorneys. And I'm not allowed to say, hey, an attorney is a great attorney or not a great attorney. I'm just not allowed to do that. But this is what I will tell you. Your attorney cannot force the state to give you what you want. If you want your case dismissed, yes, your attorney can bring information to the state, perhaps show them why the case should be dismissed. But the state could still say, no, we're not dismissing it. So he can't force them. He doesn't walk around with dismissals in his back pocket and just saves them for whoever he wants to give them to. And the state will make an offer. The defense can go back with the state and say, hey, my client will not accept this offer, but my client is willing to accept another offer, which would be a counter offer. And the state could say, you know what? No, we're not accepting your counter offer. We're not moving from where we are. So your question today is, do you want a jury trial or not? Because your plea deadline date is today.
So you're saying that he has a right to, he's obligated to speak for me, and that's what I'm saying, that I need an attorney because he refused to speak on my counter offer or anything like that.
No, excuse me, just 1 second. I am sure because attorneys ethically must present offers to the state. So you're trying to say that this attorney didn't present your counter offer?
Yes, ma'am.
All right, well, let's do that right now to be sure for you that he has presented the counter offer. Mr. Maurer, if you could go to the state and tell them what his counter offer is. I'm assuming you've already done that, but if you could just do that one more time for me, please.
I will be happy to do that.
All right, thank you. So have a seat. He's going to go to the state with your counter offer. And excuse me, Deputy Mejia, can you send him on the end so that he can hear Mr. Maurer come with the counter offer? Who is here on Victor Alvarez? All right, the court is calling 2000. Oh. Deputy Mejia,
Yes.
if you want, he can remain seated over there
Okay.
because I see he's on crutches. All right, the court is going to call 2021 CR 2955 State versus Victor Alvarez Jr. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
And are you Victor Alvarez? All right, Mr. Alvarez, did you review the motion to revoke community supervision with your attorney? Did you understand it? Are you the same Victor Alvarez Jr. who's placed on community supervision in 2021 CR 2955 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on July 15, 2021 for a term of 4 years and extended for 2 years? Is that you? All right, state.
Violation of condition number 55. On or about the 14th day of May, 2025 in Travis County, Texas, the defendant, Victor Alvarez Jr., did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged from the Austin Transitional Center in violation of condition number 55.
How do you plead to that? True or not true? Well, you either plead true or not true. All right. Did you understand by pleading true to violation of condition number 55 The court could find it true, grant the motion, sentence you to 4 years in the prison and $1,000 fine. Did you understand by pleading true to violation of condition number 55, the court could grant the motion and sentence you to 4 years in the prison and $1,000 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition 55? Court will find violation of condition number 55 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to grant the state's motion to revoke probationer, but to sentence probationer to 3 years TDC.
Yes, Your Honor.
All right. Any objection to the court reviewing the court summary?
No objection from the state.
All right. So, Mr. Leal, you want to address the issues with his discharge?
Judge, I think my client, obviously he's an addict. He tried to conform with the regulation. I think it was just based on his refusal to take a drug test. That's why he was discharged.
But the report is saying a fake UA and also possession of drug paraphernalia inside a rehab center.
I don't know how that come about. My client was just telling me that he refused to take a drug test.
All right, but then they have the drug paraphernalia as well inside a rehab center.
That's bad.
So he's not trying very hard. All right, probation. Did he pay the fee for the testing of the drugs in the amount of $57? Is there anything you wish to say, Mr. Alvarez? Yes, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. No, state your name for the record. All right, so why are they saying you have drug paraphernalia inside a rehab center? Just 1 second.
Because when they found it, that's not even.
No, just 1 second.
What they found there wasn't even what I messed with. I used to mess with heroin. I was in drug court too.
Mm-hmm.
And I've been clean for like what, almost 5 years, and they want to say that it was really a bolo. So that wasn't really what I used to mess with. And
Okay.
then as a fake urine, it wasn't even, there was somebody else who came out with that fake urine. I don't know how is that. And I even told them I would take another UA, but they never even told me that I refused to. I never told them that I refused to take a UA at first.
All right. Is there any other questions?
No question.
All right, the court is finding violation of condition number 55 true. The court will sentence you to 4 years in the prison, give you credit for any time served. There's $1,000 fine. The court will recommend the therapeutic community. Court will give you credit for any successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. So, Mr. Alvarez, the therapeutic community doesn't increase the time that you're in custody, but hopefully it can help you with any drug addictions you may have. Good luck to you. Thank you, sir.
Next up, we meet a defendant who claims his own lawyer refused to present a counteroffer to the prosecution. This moment is incredibly tense because it strikes at the heart of what every defendant fears: being unheard by their own attorney. The judge handles it calmly but firmly, turning the courtroom into a stage for transparency. Notice how she doesn't take sides. She simply orders the lawyer to represent the counteroffer right now, on record. That's accountability in action. Viewers, what do you think? Should the defendant get a new lawyer, or does this judge's quick intervention solve the problem?
Court is calling 2025 CR 001491 State versus Jamila Richardson. Can I have parties announced?
Megan Galloway for the state.
Robert Donna for the defense.
We'll wait for him to finish on his phone. All right, and are you Miss Richardson?
Yes, ma'am.
All right, Miss Richardson, did you review the document entitled Defendant's Consent to Appear by Video Conference with your attorney? Did you understand it?
Yes, ma'am.
And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, have you reviewed all discovery with your client?
Yes, Your Honor.
And did you receive all discovery?
Yes, I have.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment, Ms. Richardson, with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor. Is there
Enhancement.
okay, we'll waive the enhancement.
Any objections?
No objection, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form? I'm sorry, just one moment. All right, sorry, I was checking the indictment. It's correct. All right, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Richardson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the waiver of appeal? I'm sorry, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is waiving the enhancement. They're asking that your punishment be assessed to 2 days in the Bexar County Jail under 1244. There are no applications. There's to be restitution, if any, to Coles, KOHLS, and there's to be no contact with Coles. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
It is, Judge.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
We are.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states one in attachment.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing? All right, why are you stealing? Why can't you stop stealing?
At the time,
This next story dives into one of the court's hardest challenges: addiction versus responsibility. Victor Alvarez faces the consequences of violating probation inside a rehab center. The irony is heavy. A man sent for recovery is now punished for allegedly bringing drugs into the very place meant to save him. His lawyer insists it was a misunderstanding, a false accusation tied to a fake urine test. But the judge isn't buying it. The courtroom tone turns stern, almost maternal, as she balances compassion with consequence. Should addicts be punished for relapse or treated for it? Let's see how the ruling lands.
I just needed clothes at the time.
Well, did you go into the store wearing clothes?
Yes, ma'am.
So you had clothes. And then the person you were stealing with had $760 in her wallet. Last time I checked, that 2 Nike hoodies from Kohl's is not $760. Why didn't you all just pay for it?
Because that wasn't my money.
All right, so why are you stealing? I don't understand this. If you want something, you get a job and you work for it.
Yes, ma'am.
And this is not the first time you're stealing. That's why this is a state jail felony, because you stole twice before. You continue to steal. Did you have a job at this time?
No, ma'am.
So your thing is, I don't have a job, let me steal. What do you think would happen if everybody decided to steal? Like, I don't have a job, let me go steal. And I'm assuming the only reason why you're offered this is because you previously been in the hospital and that she's bedridden. That's why she's being offered this.
It is pretty much.
I mean, otherwise, this should be you going to prison, because obviously you're old enough to know that you should not be stealing. And then the person you're stealing with, who has the $760, they end up having to be taken to the hospital because their blood pressure was high and their insulin was off. And they had $760, but they just chose to steal. All right. Court is finding you guilty. This is going to be a felony conviction on your record. The court will sentence you to 2 days in the Bexar County Jail under 1244. There's to be no contact with Kohl's. Where have you stolen before? What other stores have you stolen from the 2016 case?
It was just Kohl's and JCPenney's.
All right. And then there's, again, with the clothes. And then there's to be no contact with JCPenney.
Yes, ma'am.
And I see on those cases, they gave you 1 day in the Bexar County Jail, and I'm assuming it's for the same reason, because she's ill, but she's not too ill to steal. So it's going to be 2 days in the Bexar County Jail under 1244. There's to be no contact with Kohl's or JCPenney, and restitution, if any, to Kohl's. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and electronically sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Richardson, the fact that you are bedridden, that will only get you so far. At some point, somebody is going to give you the sentence that you deserve. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. All right, who's here on John Castro Lopez?
Morning, Your Honor.
Good morning. Where's your client?
He's in custody, he's right there.
He needs to come down.
Too many things on my left, sorry.
No, I mean, the defendant needs to come down too.
Of course.
All right, so an offer is due today.
Yes, Your Honor,
And did you tender an offer?
I have.
All right, sir, how old are you?
28.
All right, Norma, set this for a plea deadline date in 2 weeks, please.
Honor,
Yes.
I wanted to raise something before we set a date. This is a first degree felony,
Yes.
and based on last week, you appointed someone else on the first degree and myself as second chair,
Yes.
it seemed like that might be an appropriate thing to do in this case. And I'm just suggesting that. And I wanted to see if you'd be willing to appoint Mr. Leal as first chair and myself as second, because this is a first degree felony. I thought it was actually a third when I got it. And Mr. Spear has indicated that it is first degree, so.
Okay, so are you on the first degree, Will?
No.
All right, so then we'll need an attorney appointed for first degree.
And Mr. Leal is an attorney first degree.
All right, so Norma?
Yes.
Mr. Leal is to be placed as first chair on this case. And then set this for a plea deadline date in 3 weeks, and co-counsel will tell you what's been going on.
And Your Honor,
Yes.
on the offer, I may have misunderstood, but my understanding was that the state was still considering the offer.
Well, Judge, I have an approved offer, but there is something that when it was discussed with the district attorney, I think his understanding of it might be different than what it actually is. So I'm just going to go back and seek clarification. So the offer I've extended an offer, the offer may change.
All right, so your plea deadline date is in 3 weeks. What date? All right, August 18th.
Thank you.
All right, once you sign the reset form, you're excused, and I need an acknowledgement of discovery signed before you leave. All right, thank you.
Or that, Judge.
No problem. All right, so Gabriella Medellin is going to be recalled for Thursday.
And also that other case you just gave, Judge.
All right. And that case is, what is the name of that case, counsel?
That case, you just,
Anaya, could I see the file on Anaya, please? All right, your client did not appear today, and I know there'll be some issues because the previous attorney, no contact. So I'm gonna recall this for Thursday, but I'm gonna note that she did not appear.
do I have contact information? I can try to,
If you can ask them if she's on a commercial bond, because if she's on the commercial bond, then they would have contact. Lindsay Tariano, if you can come down, please. Hello.
Hello.
Hi. Hi, your attorney is out of state. Have you had contact with your attorney?
No,
All right, would you like to keep this attorney, or would you like another attorney appointed to represent you?
I would like another attorney.
All right, just have a seat. We'll make sure we get you an attorney, okay?
Would it be today or?
Yes.
Okay, good.
Christopher Medellin, correct?
yes, correct.
All right. So today is your plea deadline date. Do you want a jury trial or a bench trial?
I'm trying to see if I can get a different, court appointed counsel.
No. This is your court appointed attorney. So do you want a bench trial or a jury trial? Or have you all reached an agreement?
As I conferred with Duffy, he extended a new offer. I conveyed it to my client, let him read the file, he's aware of the discovery. I generously support his motion to get a new lawyer. I'm sure there are many better than me in the courthouse. And
I
want
disagree with
to
that.
be effectively represented. So if the court wants to appoint somebody else, I
No.
think will not be here.
No. Court will not be appointing you a new attorney. This is your attorney. If you want another attorney, you'll need to hire one. So my question for you, today is your plea deadline date. Have you reached an agreement? If you have not reached an agreement, then your plea deadline will have expired and your next setting is going to be a jury trial or either bench trial.
I mean, I have a little bit of time to hire an attorney in.
All right, your plea deadline date has expired. The court will not consider any plea bargains in this case without good cause. All right, do you want a bench trial or jury trial?
Jury trial.
All right, Ms. Ferguson, if you can give them a jury trial date, it should be short. It's a robbery. So I'm thinking, including jury selection, what, 2 days?
Well, there's a robbery, felon possession of firearm.
Okay, I just have the robbery. Is there another case? Let me see. that may be on a different docket for a different day. So Norma, 3 days, jury trial.
And now, the case of Jamila Richardson. The judge's tone shifts from patient to piercing as she asks one question that cuts to the core. Why are you stealing? This isn't just legal reprimand, it's moral confrontation. Richardson admits she stole clothes despite having them already and despite her partner carrying $760 in cash. It's a moment that's both frustrating and tragic. You can hear the judge's disbelief, not just at the act, but at the pattern. Theft, illness, pity, it all collides here. Do you think leniency was the right call? Or should repeat thefts face stricter punishment?
All right, you're coming back on September 23rd for your jury trial date. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. And Mr. Duffy, could you do an acknowledgement of discovery,
I'll
please?
get that right now, Judge.
Thank you.
23rd is for a board hour.
Yes. And if you do hire an attorney, you need to let them know they need to be ready for trial on September 23rd. Do you understand? All right, thank you. Mr. Meyer, once you sign the acknowledgement,
Okay,
then you're excused with regards to Mr. Medellin.
thank you, Judge.
Thank you. All right, who are the parties on David Alonso Saldivar? All right. State what is happening with this case?
Judge, we do have a proposition for the
Yeah.
court that would resolve everything, but it would include a withdrawal and an alternate amends for conditions to address certain issues, but it would take care of all of defendants.
And what are you all requesting with the alternate amendment?
For state ISF, inpatient address substance abuse issues.
And I believe that you were gonna extend first.
There would be an extension proposed as well. And we have spoken with probation about this. For today's contested, this arrangement would allow for probationer to address these issues in a sense that the state would not be able to achieve today.
Ms. Abrams? On Mr. Saldivar? Yes. Thoughts?
I did speak with Duffy on Friday, and we felt like that was the best thing to do at this point.
All right, who's the complainant on the new case?
If the state
To answer that question, Your Honor, the complainants on the new number ones for family violence were his parents and sister.
And what are their names? What's your parents' names?
David, Elizabeth, and my sister's Angela.
And your sisters who?
Angela.
All South Park.
So what is going on with him? Does he have mental health issues?
Yes, Your Honor, you and initially when he started probation, he's getting toward the end of that. But when you started probation, you originally ordered DDRF. However, he was bounced out of that. They was not qualified for whatever reason. And his family does want him to have. They understand that he has problems with substances and things.
Okay, you're trailing off.
Sorry.
I can't hear a word you're saying.
Mr. Saldivar understands that he has, and his family understands that he has substance problem use treatment. Also.
All right, so I don't know how state ISF probation, how is that going to address mental health issues?
I think we're focusing on the substance abuse
Mhm.
factor of it. I don't know necessarily.
Does it sound about it?
Mental health issues. He has been or was on at one point in time to make caseload. I
Mhm.
was just reviewing that.
I mean,
Angela.
would felony drug court take him or no? Because they have their dual diagnosis program. All right.
I think perhaps, Your Honor, Mr. Saldivar does have some anxiety issues. I think perhaps that the family thought that behavior may be more mental health related. However, it was, those instances were all related to the influence.
All right, so if he has anxiety issues, I don't know how he's going to do well in ISL. Because I'm writing a different program than what you all have come up with. And if he has anxiety, then I don't know how he's doing at the jail. If he has anxiety, I don't know how he's going to do in ISF. So that's something that they can address in their dual diagnosis program if they accept him.
Yes, Your Honor, you're talking about the felony drug court? Okay. Well, Mr. Saldivar does want treatment for his issues. It has been a little bit of a struggle for him being in jail. He's mentioned that, but he's working with the situation. We're just trying to tailor it so that he's able to get the help he needs, the family wants.
Okay, you keep trailing off.
I'm sorry, Your Honor.
And I
Sometimes I
can't
get
hear.
too loud.
No, you're not loud at all. You're trailing, you start here and then you go down and I can't hear the rest of it.
I apologize, Your Honor. We were just trying to tailor the situation so that he's able to get some, he's never had a proper intake treatment. And we were going to try to tailor the situation to find.
Oh, felony drug court will tailor the situation if he is accepted. I mean, he has, here are your choices. Your choices are the state wants to withdraw the motion. They want to alternate amend your conditions. So the only thing that's going to end up happening is either you're going to get accepted in a felony drug court, you're not going to be released from custody, or either you're going to ISF and you're not going to be released from custody. So that's it. Now, if you want to, the state can proceed. You can plead to true to one of the violations and the court will hear if they have come to an agreement. But otherwise, your probation today is getting extended for 2 years. That's what's going to happen. If they're withdrawing and they want to alternate amend, it's going to be extended for 2 years. You're going to remain in custody. You're going to be referred to felony drug court while you're in custody. And then if they don't accept you, you're going to go to ISF. That's what's going to happen. And then you're going to be put on GPS and there's not going to be any in-person contact with David or Elizabeth or Angela. And you're not going to be living with David, Elizabeth, or Angela.
And Your Honor, if the family contacted me to get an affidavit for change to no harmful or injurious.
No.
No.
Because we're here and in this motion to revoke, it has terroristic threat ×3. And I'm assuming that's involving his family members. And then there's also an interfering with emergency request for assistance, which means somebody was on the phone, allegedly calling 911 and you stopped them from doing that. So, no. Or if those are going to be the court's conditions, or if you want to be revoked, you can plead true to something and the court will revoke you.
I don't believe we have any objections, Your Honor.
All right, so probation. Then the state is asking that the MTR be withdrawn. He's going to be extended for 2 years. And in custody, I want a referral to felony drug court first. And if not accepted, then the referral to ISF. And then, are you employed? Were you previously employed?
I'm working as I'm a painter. I was doing odd jobs around. I
All right.
couldn't find solid employment could do the transportation.
All right, via bus.
It doesn't go up to Bernie. I mean, it gets a company. It's complicated.
So
yeah.
here's the thing. This is what people have to understand. I understand when people don't have transportation. I understand when people, the via bus doesn't run to certain locations. I myself, and I've had family members, guess what? When they didn't have a ride, they timed what time they needed to be at work and they walked. I mean, are we living in a society where we say we don't have a ride, via bus doesn't come here, so therefore I cannot work? I would love to do that, not work and still be able to afford to live like I want to live. Everybody needs to get a job. So there's going to be partial GPS for employment, waive fees,
Your Honor.
and that will be upon release. Is there anything else that you need from the court to be successful?
I had nowhere else to live with my family on.
Not going to happen.
I don't know where else to go.
Felony drug court, if you're accepted, if you're honest with them, they will accept you and they will help you find housing. Do you understand? And there's to be no in-person contact with David, Elizabeth, and Angela Aguilar. I'm sorry, Angela Saldivar. And the reason why I'm doing that is because this could have really turned into something completely different. And then you would have been here for something that's more serious than just a terroristic threat. Once you are stabilized, then your attorney can always reapproach the court and I'll reconsider lifting it and making it no harmful or injurious.
Thank you.
All right, is there anything else you need?
Can I speak to them?
Sure. Yes. You just can't have in-person contact. That means that you can't go to the house. You can't see them face to face. You understand? But you can call them on the phone. You can even, and I say face to face, you can even do a video conference with them, but you are not to see them in person. Do you understand? All right.
And just for the record, Your Honor, I should mention that as part of the agreement to agree to extend the probation, the state's going to be fine with Smith-Delany. 2025 CR 008047.
All right. Once they give me the dismissal, I will sign it.
Yes, ma'am. Thank you.
All right. Is there anything else you need? Yeah, now's the time.
You can always call me too. You can always call me too.
I'm
All right.
good. Thank you.
All right, you're welcome. And if you ever need anything, let probation know. And if you feel they're not addressing it, you can always come back to the court.
Thank you, Your Honor.
All right, good luck to you.
Thank you.
You're welcome.
That's what's this here.
All right, is the party here on Leonardo Solis Arredondo? All right, where's your flight? Hi, how are you doing? All right, today is your plea deadline date.
Yeah, Judge, as you can see, I'm not Mr. Ashbaugh. I'm standing in for Dirk. He's in trial in Bandera County. I did confer with the prosecutor. I've at least conveyed the offers to him. He does want time to speak to Mr. Ashbaugh and have him present for that.
All right, Ms. Ferguson, recall this for Thursday.
And Your Honor, it's my understanding he'll be in trial the entire week. He was asking for something after August 11th. I believe he's in trial and I think he's out of town, but I'm not 100% sure on that. But he did tell me to ask for after August 11th.
All right, so you say he'll be in trial for a week?
I believe so, Judge.
All right, Ms. Ferguson, recall it for August 4th. And that will be your plea deadline date.
All right, thank you, Judge.
You're welcome. Once you sign the reset form, you're excused. And Mr. Arredondo? Just go to anyone. Sometimes you go in there, you don't have to talk to anybody. They just welcome you. They have coffee and donuts, and you can just sit there and listen. And then just do the first one, then do the next one, okay? And if you need any other help with that or some type of inpatient facility or something like that, if you come back to court, if your attorney doesn't have any objection, I'll pick up the phone, call somebody and see if they can put you in an inpatient facility, okay? All right, so I'll see you back on August 4th. Once you sign the reset form, you're excused. All right, could I see the parties on Lindsay Tariano, please? All right, so you had a chance to meet with your attorney?
Yes, ma'am.
Okay. All right, Ms. Ferguson, if I can have a 3-week reset for discovery. All right, so we'll come back on August 19th for discovery. And state, you need to be prepared to tender an offer.
I tendered a global offer this morning to counsel. Yeah.
Okay.
But I would like to review the discovery before we officially decide.
So we'll put the discovery at August 19th. The court will note that the defendant has all of the discovery, and the court will note that an offer has been tendered.
And there was one other matter, Your Honor.
Yes.
I believe he's remand right now. Not
All right.
sure.
Is there a reason for the remand? Do you know?
Well, I think what happened is that he violated one of the conditions of his bond by looking for work without permission. Tells me that he called 25 to 30 times. His officer couldn't get anyone, so he decided that in desperation to look for work. And in the process, the monitor went off, of course, and he got a violation for violating the monitor.
All right, you'll need to set it for a hearing
Okay.
because I need to see exactly what the issue is, and then the court will hear it.
Very good.
Just speak with Ms. Ferguson about that.
All
All right, thank you. All right, who is here on Jesse James Lewis? And there are no applications. All right, court is calling 2025 CR 007751 and 2025 CR 007752, State versus Jesse James Lewis. Could I have parties announced?
Megan Galloway for the state.
Glenn Payne for defense.
And are you Jesse James Lewis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lewis, did you review the true bill of indictments with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictments?
Wait.
State and cause number 2025 CR 007751. Are you proceeding on the indictment as presented?
Yes, Your Honor. And the cause number ending in 7752, we are waiving the enhancement.
All right, any objections to the waivers?
No objection, Your Honor.
And each cause number, Mr. Lewis, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 51, you're charged with unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 52, you're charged with evading arrest detention with a vehicle with a previous conviction or SBI is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have plea bargain agreements with the state, the court does not have to follow your pleas. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering these pleas, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
And each cause number, counsel, has your client been able to provide you with any defenses?
We discussed the cases and no defenses that we can present to the court.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion, yes.
Mr. Lewis, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement and the cause number ended in 5-1, punishment is to be assessed under 1244 at 94 days in the Bexar County Jail. There's a $2,000 fine. Cases will run concurrently, and the state will take in consideration 2025 CR 007750. And the cause number ending in 5-2, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. Cases will run concurrently. The state will take in consideration 2025 CR 007750. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2025 CR 007751, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And cause number 2025 CR 007752. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states one in attachments.
Your Honor, I review these with my client. We have no objection.
All right, state you may be excused. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same for sufficiency. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client, spoke about this case. He just asked the court follow for plea bargaining as written.
All right, in cause number 2025 CR 007751, the court is finding you guilty. The court will sentence you to 94 days in the Bexar County Jail under 1244. You get credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 007752. Take in consideration 2025 CR 00750. And there's to be restitution, if any, to Sally Ann ANE Pryor. Is there anything with regards to sentencing under that cause number? Counsel?
No, Your Honor.
Cause number 2025 CR 007752. Court is finding you guilty. Court will sentence you to 3 years in the prison. Credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 007751. Take in consideration 2025 CR 007750. And there's to be restitution, if any, to Sally Ann Pryor. Anything else with regards to sentencing and under that cost number?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal in each of these cause numbers?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
22.
All right, so you're gonna have to make a decision. Do you want to live the rest of your life in somebody's prison? Because let me just tell you, no matter how much money the state says they do not have, how much money they run out of, there's one thing they always have enough money for. And you know what that is?
Prison.
Prisons and jails. So you had better change your ways. Otherwise, you're gonna spend the rest of your life doing that.
I don't know. I'm learning.
And here's the thing, I have no problem with tattoos, but if you do face tattoos, your employment opportunities are going to be limited because people see that. Some people don't like it. Some people are fine with it. You know, you're okay with it if you're planning on playing in a band or something, but otherwise people are going to say, nope. All right.
Yeah.
All right. Good luck to you.
Thank you.
You're welcome. All right. Who is here on Alexander Aguilar? All right. Court is calling 2024 CR 012220. State versus Alexander Aguilar. Can I have parties announced?
Rick Pena for the state of Texas.
Kyle Simpson for Mr. Aguilar.
Are you Mr. Aguilar?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
And did you review that with your attorney?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, Sigel proceeding on count 5 of the indictment and will waive the other counts.
Any objection?
None.
Additionally, Your Honor, Sigel will waive the habitual offender enhancement.
And I'm sorry, are you waiving? Oh, and you're waiving count 6. All right, so for the record, the state is waiving the habitual enhancement allegations, counts 1, 2, 3, 4, and 6. Is that correct?
Correct. Yes, Your Honor.
And you're proceeding on count 5?
Yes, Your Honor.
All right. Any objections to those waivers?
No, Your Honor.
Mr. Aguilar, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with sexual assault of a child? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 5. Punishment is to be assessed at 16 years in the prison. There's a $1,500 fine, no applications. There's an affirmative finding of family violence. There's to be no contact with the complainant and lifetime sex offender registration. Did you understand that to be the plea? Defense, is that the plea?
It is.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then to count 5, how do you plea?
No contest.
State, any evidence?
At this time, State offers the evidence is Exhibit 1 with all attachments.
Without objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, why is there an estimated range in here for, it says DLB or estimated age range?
I believe it's because initially she filled out a pseudonym form.
Okay,
That's at the back of the stipulations. Your Honor.
all right, thank you.
You're welcome.
Oh, okay. I was calculating the age and I said, just bring out the age calculator.
Yes.
All right, so why should, the court is going to find there's sufficient evidence to find you guilty. Court will find you guilty. Why should the court follow this agreement?
That's what the victims wanted, Your Honor. I've spoken with both her and the mother. They're okay with it.
All right, and currently I believe she's 17.
Currently, yes, Your Honor.
All right, anything you want to say? Why are you doing this?
Excuse me.
Why did you do this? You gave up the right to remain silent. Why did you do this? That's your daughter. I mean, it's bad even if it wasn't your daughter, but why would you do that to your daughter?
Ma'am.
I mean, have you internalized what you've done?
Yes, no.
And I can't believe the mother allowed you into the home with your criminal history anyway. And when you came back into the home after you're being in prison, did you have the gang tattoos as well? And she still allowed you in the home?
We weren't together.
It was his home.
All right, so it was his home
Sorry.
where this happened. And somebody allowed their daughter to go and stay with you, and you're a gang member, and you've been to prison. All right. The court is going to sentence you to 6 years in the prison. I'm sorry, 16. Thank you. 16 years in the prison. There's to be a $1,500 fine. Credit for any time served. There's to be no contact with the complainant. There's to be Chapter 62 registration. There's an affirmative finding of family violence. There's to be no contact with minors, ever. There's to be no residing in any household with minors. So you're not allowed to reside or live with anyone who has children in the household. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? We can go off the record. So for the rest of your natural life, you're not to reside in any household with children. Do you understand?
Yes, ma'am.
The reason why I'm doing that, because I don't want you to think that I'm just doing it just to be doing it. It's because that there are women out there who think you are a good catch. And even though you're going to have this sex offender registration, trust me, there are women out there who going to think you've changed and they will let you around their children. And that cannot happen. You understand? All right. Good luck to you.
Your Honor, before we should do victim impact statements to give.
All right.
I think he has something as well.
All right. Who are the parties?